Supreme Court is considering a case on whether the federal laws, which prohibit the possession of firearms if you use substances like marijuana.
This comes after officers arrested a man and said they smelled marijuana in his vehicle and later found a gun.
Mr. Daniels, on a discussion with the police officers, admitted that the firearms were his.
Be disbarred their firearm or their rights until due process of the Fifth Amendment has taken place.
Second Amendment under scrutiny. The Supreme Court, the big kahunas of the legal world, is diving into the deep end with a case called U.S. v. Daniels. So what's all the buzz about? Well, it's all about the Second Amendment, that hallowed right to bear arms, and how it plays out when folks are blazing up or toking on something. In this corner, we've got the federal laws, particularly 18 U.S.C. Section 922G3, which are giving side-eye to people who like to dabble in substances like marijuana. These laws say, hold up, if you're into Mary Jane, you might have to say goodbye to your precious firearms. That's the drama that's unfolding. So U.S. v. Daniels is like the Super Bowl of Second Amendment cases. It's here to settle the score and figure out whether these federal laws are crossing the line. The big question is, do these laws violate our good old Second Amendment?
Supreme Court is considering a case on whether the federal laws, which prohibit the possession of firearms if you use substances like marijuana.
A federal judge in Oklahoma rules that a law that prevents marijuana users from owning a gun is unconstitutional.
Whether or not that is in fact a violation of the Second Amendment. This case has huge implications.
It's like a heavyweight fight in the legal ring, folks. Picture this. In April 2022, Mr. Daniels is just driving around minding his business when the fuzz pulls him over because he's missing a license plate. But here's the kicker. The air inside his car has that unmistakable smell of the green stuff. The cops dig a little deeper, and lo and behold, they find marijuana and loaded firearms in his ride. Oops! Mr. Daniels doesn't play coy. He owns up to the pot and the guns. He even admits that he's been buddies with Mary Jane since high school. The twist? There's no hard evidence that he was under the influence during that particular drive. But despite that, he's found guilty under Section 922G3 and gets a 46-month prison sentence. That's a lot of time for a joint and a couple of firearms. So the Fifth Circuit, a group of judges, takes a closer look. They say, hang on a minute, these laws might not jive with our good old Second Amendment. They rule in favor of Mr. Daniels. But wait, it's only for him personally. It's like a customized decision. One size does not fit all. There's also a judge in the corner who's saying, you know what, this law seems pretty messed up in general. This whole shebang goes up to the Supreme Court, and they're in for some serious pondering. The government's got an argument, though. They're saying, hey, the Second Amendment isn't a safety net for folks who like to light up. If you've been smoking the wacky tobacco, you might not get to hold your firearms anymore. But if you quit the ganja, you might win your gun rights back. Now, the Supreme Court is kind of like a referee in this match. They're deciding whether these laws are legal or if they're stepping on the toes of the Second Amendment. It's like they're trying to find the right balance between our rights and public safety. So U.S. v. Daniel is like a roller coaster ride through the legal jungle. The Second Amendment's at the forefront, and the Supreme Court is the final boss in this game. This case is bound to set some serious precedents and make us all ponder the line between gun rights and substance use. Buckle up, folks, it's going to be a wild ride. An examination of marijuana and firearm laws. U.S. v. Daniels. It's not just another legal showdown, it's a clash of the titans, where marijuana and firearms laws meet in a fierce face-off. Hold on to your seats because we're diving deep into this intriguing case. At the heart of the matter is none other than 18 U.S.C. Section 922G3, a chunk of legal jargon that carries massive implications. This section is like the rulebook, dictating who gets to hold that precious piece of metal and who doesn't. In particular, it's got its sights set on those who cozy up to controlled substances, especially our green friend, marijuana. So let's break it down. U.S. v. Daniels is all about whether this section, 922G3, plays nice with our Constitution. And that's where the drama unfolds. It's like a courtroom dance-off, but instead of breakdancing, they're wrangling with legal jargon. Here's the thing. The government says if you've been puffing on the ganja, maybe you shouldn't be toting around a firearm. They argue that if you're using controlled substances, you're not exactly on the good citizen list protected by the Second Amendment. But hold on, there's a twist. They say you can always win back your rights if you drop the habit. So U.S. vs. Daniels is the big stage, where the pros and cons of this legal showdown are weighed. It's all about whether 922G3 respects our rights under the Second Amendment, or if it's a step too far in trying to keep us safe. Imagine you're Mr. Daniels, a regular guy driving around town. You get pulled over by the cops because your car's missing a license plate. Routine stuff, right? But then that unmistakable smell of marijuana wafts through the air. That's when things get interesting. The police decide to dig deeper, and they hit the jackpot. They find not just some Mary Jane, but also loaded firearms in your ride. Oops.
In April of 2022, police officers stopped Mr. Daniels for driving without a license plate.
This comes after officers arrested a man and said they smelled marijuana in his vehicle and later found a gun.
An officer approached the car and recognized that there was a smell of marijuana. That then led to a search of the vehicle.
But here's the kicker. There's no clear evidence that you're stoned out of your mind while driving. So it's not like you were blazing up and being all reckless. But despite all that, you're found guilty under 922G3, and you're staring at a 46-month prison sentence. That's a hefty price to pay for a joint and a couple of firearms, right? That's where the Fifth Circuit comes into play. They're like the referees making the final call in this game. They take a good hard look and say, hold on a minute, this 922G3 might be a bit too much. They rule in favor of Mr. Daniels, but here's the catch. It's a custom-made decision, just for him. It's like trying on a pair of shoes. One size doesn't fit all. Now this legal roller coaster ride goes up to the Supreme Court. They're like the big bosses, the ultimate referees. They're the ones who will decide if 922G3 is playing by the rules of the Second Amendment. So U.S. vs. Daniels isn't just a legal drama. It's a debate on our rights and the line between gun ownership and substance use. It's a battle to see if 922G3 respects the Second Amendment or if it's gone too far in the name of public safety. Buckle up, folks, because this case is one wild ride through the legal jungle. Case background. Let's rewind the clock to April 2022 and dive into the real nitty-gritty of the U.S. vs. Daniels case. This is where things get juicy, folks. Picture this. It's just an ordinary day for Mr. Daniels. He's cruising down the road, minding his own business, when suddenly, the red and blue lights start flashing in his rearview mirror. Why, you ask? Well, because he's got a little oversight on his car. It's missing a license plate. Now, you'd think a missing license plate would lead to a simple slap on the wrist and a reminder to get things sorted. But hold on to your seats, because this encounter takes a wild turn. As the police officer approaches Mr. Daniels' vehicle, something in the air catches his attention. It's that unmistakable scent, that aroma of, you guessed it, marijuana. You can almost hear the dun-dun-dun music in the background, can't you? The scent isn't just a faint whiff. It's like a neon sign flashing, investigate further. And so they do. The officers decide it's time to take a closer look at what's going on inside that car. Lo and behold, they uncover not just a little weed, but also something that really gets their attention: loaded firearms. Yes, you heard it right. Guns right there in the vehicle, ready to go.
Where the officers uncovered that there were several marijuana cigarette butts, roaches in the ashtray. They also found a loaded pistol.
I just don't want to sell a gun to you today. You smell like weed. I'm sorry.
Mr. Daniels, on a discussion with the police officers, admitted that the firearms were his.
Now, you'd think this would make for an action-packed Hollywood movie, but it's a real-life legal showdown. But here's the kicker. There's no clear evidence that Mr. Daniels is high as a kite or under the influence during this particular drive. It's not like he's zoned out, recklessly blazing up and driving like a maniac. Yet, despite all this, he gets hit with the heavy hammer of justice. He's found guilty under 922G3, and the consequences are pretty hefty. He's staring at a 46-month prison sentence. Oh, and there's more. A 3-year prohibition on top of that. So, in a nutshell, this encounter with the police officer on that fateful day in April is what kick-started the whole U.S. vs. Daniels legal drama. It's like a domino effect that's led us to the big showdown in the Supreme Court. Will this seemingly routine traffic stop turn into a game changer for our rights? Only time will tell. The Fifth Circuit's as-applied decision. The Fifth Circuit's role in the U.S. versus Daniels case is like a crucial plot twist in a legal drama. This is where the rubber meets the road and the law starts taking some unexpected turns. So here's the deal. After Mr. Daniels' somewhat unusual traffic stop, the case made its way up the ladder to the Fifth Circuit. This isn't just your run-of-the-mill court, it's a big deal in the legal world. They had a daunting task ahead of them, like judges often do, and their job was to scrutinize the application of 922G3, a legal section that's about as clear as mud. This section essentially tells us who gets to have firearms and who doesn't, especially when you're dancing with substances like marijuana. Now, the big question for the Fifth Circuit was whether this 922G3 rule was playing nice with our good old Second Amendment. Picture it as trying to fit a square peg into a round hole. It's a tough squeeze. After some intense legal acrobatics and careful thought, the Fifth Circuit rendered their verdict. Here's the twist. They ruled in favor of Mr. Daniels. But wait, it's not a one-size-fits-all kind of decision. It's more like a tailored suit, made to measure for Mr. Daniels himself. In other words, they say, hey, Mr. Daniels, you get to keep your rights.
This case involves whether those people who use maybe recreational drugs like marijuana should be permanently barred from possessing firearms.
Be disbarred their firearm or their rights until due process of the Fifth Amendment has taken place.
By any person who is claimed to be an unlawful user of or addicted to any controlled substance.
But, and there's always a but in legal terms, there's a judge in the corner, Judge Stephen Higginson, who has some thoughts. He basically says, hold on a second. While this decision might be limited, it's hard for me to believe that it's just about Mr. Daniels. It's like a recipe for future cases. So here's the catch. The Fifth Circuit didn't come crashing down on the entire 922G3 rule. They didn't say it's all good or all bad. What they did was throw up a red flag, a warning sign that says, we might need to take a closer look at this in the future. It's like planting the seed for what's about to be a legal fireworks show. And this red flag is what set the stage for the epic showdown in the Supreme Court. U.S. versus Daniels is now making its way to the biggest legal arena in the land. The Supreme Court is like the grand stage, where all the big decisions happen. They're about to decide whether this 922G3 rule is in line with our constitutional rights, particularly our beloved Second Amendment. So buckle up, folks, because what the Fifth Circuit did, while it might seem like a small step, is actually a giant leap towards a courtroom battle that's bound to set some serious precedents. U.S. versus Daniels isn't just a legal drama, it's a turning point in the ongoing debate about our rights and the line between gun ownership and substance use. It's a wild ride that's just getting started. Government's argument. Now let's turn our attention to the heavyweight contender in the U.S. versus Daniels showdown, the government. They've got a case to make, and it's a real game changer. The government's argument is straightforward, but loaded with implications. They're saying, hold on, folks, the Second Amendment isn't a one-size-fits-all deal. According to them, it doesn't protect just anyone and everyone. In their view, if you're dancing with controlled substances, especially marijuana, you're not exactly on the good citizen list protected by the Second Amendment. In essence, the government suggests that these individuals are straying from the path of righteousness, at least in the eyes of the law. They're, metaphorically speaking, in the naughty corner. It's like saying, hey, you're not part of the protected class of people we had in mind when we wrote that Second Amendment thing. But here's the kicker. The government says, it's not all doom and gloom. If you've been dabbling in the world of controlled substances but decide to clean up your act, you might just win back your rights.
So basically it's saying if there hasn't been something like this done in all of our history, then it can't be imposed, right?
I think worse than that, sir. You will see millions of otherwise law-abiding citizens
that had you prove some type of special need in order to get a permit.
It's like a second chance, but it comes with some conditions. Drop the habit and you could potentially be back in the good graces of the Second Amendment. So in this corner, you've got the government waving the flag of public safety and responsible citizenship. They're saying, we're all about making sure firearms are in the right hands. In their eyes, you're not in the right hands if you've got one hand on a gun and the other on a joint. It's a real tug-of-war between rights and responsibilities, and U.S. versus Daniels is where it's all going down. The Supreme Court is the ultimate referee in this match, and they're the ones who will decide if the government's argument holds water. It's a decision that could have far-reaching consequences for how we view our rights, and the line between gun ownership and substance use. The stage is set for a legal showdown, and it's one for the history books. Impact of U.S. versus Rahimi on firearm possession. Now, let's take a detour to another pivotal legal battle that's closely connected to U.S. versus Daniels. It's like a chess match, and every move matters. We're talking about U.S. versus Rahimi, and it's got its own set of cards to play in this high-stakes game. In U.S. versus Rahimi, the government is crossing its fingers for a favorable outcome, and here's why it matters. This case tackles a different facet of the same beast, 18 U.S.C. Section 922G, which happens to be the rule for firearm possession, just like in the Daniels case. Here's the twist. U.S. versus Rahimi isn't about marijuana or controlled substances. It's about a different piece of the puzzle. It focuses on folks who might be on the wrong side of the law due to domestic violence restraining orders. The question is whether these individuals should be allowed to own firearms, ammunition, and other gun-related goodies. Now, the government sees U.S. versus Rahimi as their golden ticket. They're hoping for a favorable decision in Rahimi that swings the pendulum in their direction. You see, Rahimi is a different kind of character than Daniels. It's like they're rooting for the hero in a different story. Why? Well, because Rahimi isn't exactly a poster child for good behavior. He's not the innocent Mr. Daniels driving down the road. The government is banking on Rahimi as a precedent. If Rahimi lands in their favor, they're planning to use it as a powerful argument in the U.S. versus Daniels case. It's like saying, "Hey, Supreme Court, you already decided on one part of this puzzle in Rahimi. How about you take a closer look at Daniels with the same lens?"
Yes, exactly. It's adopting a purely historical test.
The co-chair of the Second Amendment Caucus, Mr. Massey.
This is a national thing that can affect millions of Americans.
They're going to have to show that there weren't other less restrictive.
So the impact of U.S. versus Rahimi on firearm possession isn't just about one case. It's about a domino effect. If Rahimi sets a precedent, it could influence not only Daniels, but other related cases in the legal pipeline. It's like a ripple in a pond, and it's about to make some waves in the world of firearm possession and rights. So when you're watching U.S. versus Rahimi, remember that it's not just about one guy and his firearm rights. It's about the bigger picture and how these legal battles shape our understanding of gun ownership and the law. The legal world is a complex web, and one case can tug at the threads of many others. Overbroad nature of Section 922G3, a legal perspective. Now let's shift our focus to one of the key criticisms bubbling up in the U.S. versus Daniels case. It's like a spotlight on the stage, and it's all about the perceived problems with 922G3, that rule that's causing all the legal ruckus. Critics, and there are quite a few of them, are pointing fingers at 922G3, saying, "Hey, you're just too darn broad." It's like trying to swat a fly with a sledgehammer. In their view, this section is overly aggressive and it's overstepping its boundaries. Here's what's bugging them. 922G3 doesn't just tap its foot at the line of intoxication or misuse, it takes a giant leap across it. This section, according to the critics, says, "You've had even a tiny taste of a controlled substance? Well, say goodbye to your firearm rights." It's like saying you can't drive, not because you're drunk right now, but because you had a sip of beer last week. They argue that this rule doesn't have a leg to stand on when you look at history. It's like trying to find a unicorn in the forest. It's just not there. Historically, the laws around firearm possession have been about real intoxication or misuse, not just a whiff of something. All the laws in the past dealt with alcohol and, more specifically, being under the influence, not merely having indulged at some point in the past. It's like saying you can't drive because you had a glass of wine a month ago. The critics are waving the historical flag saying, "This is just too much, you're going too far." So when you hear the critics talk about the overbroad nature of 922G3, they're essentially saying it's like using a sledgehammer when a fly swatter would do. It's like applying a rule that's just too wide and doesn't respect the boundaries of common sense. U.S. versus Daniels isn't just about Mr. Daniels and his case. It's about challenging a rule that critics believe goes beyond what's fair and historically supported. The legal world is watching closely, and the Supreme Court is the ultimate judge. It's a fight for the interpretation of the law and what's right or wrong when it comes to firearm possession.
There's a hearing that you can't be at, your counsel can't be present, you haven't been charged with the crime.
There are many areas, as you might imagine, especially when you're dealing with firearms, where we just don't know.
But now there is a right to possess a handgun outside the home.
The stakes are high, and the outcome could have far-reaching consequences for many. Potential implications for Second Amendment rights. Now let's fast forward to what's arguably the most crucial part of this legal drama, the potential implications. The outcome of U.S. versus Daniels isn't just about one guy in his case. It's a crossroads that could shape the entire landscape of Second Amendment rights and firearm ownership in the U.S. Picture it like this. If the Supreme Court makes a ruling in favor of Mr. Daniels, it could be like opening a door to a broader interpretation of the Second Amendment. It's like saying, hey folks, you might have more leeway when it comes to your rights in owning firearms, even if you've dabbled with some substances in the past. On the flip side, if the ruling goes against Mr. Daniels, it's like slamming the door shut and reinforcing stricter limitations on firearm ownership for individuals who have ever used controlled substances, like marijuana. It's saying, we're taking a stricter stance on this, and you'll have to walk a narrower path to exercise your Second Amendment rights. These potential implications aren't just about Mr. Daniels or his specific situation. They're about all of us and how the law interprets our rights. It's a debate that stretches far and wide, touching the lives of countless Americans who cherish their right to bear arms.
Not only to possess a handgun in your home for self-defense,
of any semi-automatic assault weapon that was lawfully possessed before the bill became law.
And we reached the owner of Rare Breed by phone. They said they're resubmitting evidence.
So as we watch U.S. versus Daniels unfold, remember that it's not just a case, it's a turning point. It's about the boundaries of our rights and the line between gun ownership and substance use. The Supreme Court is the final referee, and their decision will send ripples throughout the legal world. The outcome is uncertain, but one thing's for sure, it's a showdown with far-reaching consequences. Call to action. Now that we've dissected the ins and outs of U.S. versus Daniels, it's time to take a look at what you can do to support Second Amendment causes and make your voice heard. If you're passionate about protecting your Second Amendment rights and want to see how the legal landscape unfolds, you're not alone. There are organizations out there, like the Firearms Business Council, that are fighting the good fight on behalf of responsible gun owners. They're like the unsung heroes working behind the scenes to ensure your rights are upheld. So here's your call to action. Get involved, speak up, and support the organizations and businesses that share your passion for the Second Amendment. It's not just about the legal battles in the courtroom. It's about the collective strength of citizens who care about their rights.
There is no other right where we require individuals to show a need in order to be able to exercise that right.
Contrast that with what Republicans did to address gun violence and crime the last time they were in charge.
And there's been quite a few amendments. Well, the last thing to happen just happened yesterday.
Your voice and your choices can make a difference in the ongoing debate over firearm ownership and the law. Ongoing debate, Second Amendment and substance use. U.S. versus Daniels isn't merely a case, it's a pivotal chapter in an ongoing, impassioned debate about the intersection of the Second Amendment and substance use. This dispute has profound and far-reaching implications that extend well beyond the confines of a courtroom. It's a contentious topic that sparks discussions at kitchen tables, in legal circles, and within the chambers of power. At its core, the debate revolves around the fundamental query: does the Second Amendment's protective embrace extend to individuals who may have used controlled substances, particularly marijuana, at some point in their lives? This question is akin to a spark igniting a wildfire, setting ablaze a myriad of complex, multifaceted discussions and conflicting viewpoints. The outcome of U.S. versus Daniels isn't solely about one individual's rights. It's about establishing a precedent that could potentially amplify or curtail the scope of legal limitations on firearm ownership for those who have had any involvement with controlled substances. This debate isn't a passing squall. It's an ever-present overarching theme in the realm of American law. Various cases and scenarios, much like U.S. versus Daniels, continually bring it into sharp focus. The discussion isn't confined to the legal community. It resonates deeply with the broader public, invoking spirited discourse.
Shall not be infringed.
take all of the guns from all of the people. That's their goal.
Because Bruin said that that's unconstitutional, so they drafted SB 2, which was originally introduced back in December.
The ongoing debate isn't merely an examination of the legal framework. It's a reflection of our collective ethos and our interpretation of the Second Amendment. It's a dynamic and ever-evolving conversation, one that encompasses the courts, legislators, advocates, and ordinary citizens who hold their rights dear. As U.S. v. Daniels unfolds, it serves as a stark reminder that this debate is not a passing tempest, but rather an enduring and pivotal conversation that involves us all. Whether we are legal scholars, passionate advocates, or everyday individuals concerned about the preservation of our rights, this debate influences us in ways both seen and unseen, and it will continue to do so in the days, months, and years to come. That's all for this video, folks. See you next time.